Hello, my name is Jeff. This is 2A Self-Defense Law. What we help people understand the law of self-defense in the simplest terms possible. What we do is we take the fear out of getting it wrong. Over the last, I don't know, since April or so, I've gone to 8 different concealed carry classes. And I go there because that is more than likely we're going to be taught self-defense law. And it's been horrible. I'm just going to go over the most common things. It's about 10 of them, of the mistakes that firearms instructors make when it comes to self-defense law. Andrew Bronca has just come out with a seminar that was a little bit too much of a sales pitch for me, but it lit a light under what NRA or USCCA instructors are teaching people and what they're not getting out of these classes. Because if these people have been in the industry for 5 years and they are only getting 50% of the questions right, now granted, that test really didn't do much about what stand your ground or, self-defense laws were. Not that many people are going to know about 75% of the states have some sort of a stand your ground case law or black letter law. I don't really expect people to know that type of question. But bad instructors like you are seeing here, this is a very bad instructor. Everyone's pointing guns at each other. You just don't want to do that. How do you know you have a bad instructor? Well, it's kind of difficult to know that you have a bad instructor until you get the knowledge and the experience behind it to know if an instructor is good or bad or how his teaching style is, that kind of thing. Now, I'm not going to discuss, I would give all 8 of these instructors a failing grade that I went to. The last one was probably the worst, and because it's the freshest in my mind, I'll probably be dwelling on that a lot. And we'll go from there. I would like to, you're going to hear this saying a lot, and it happens over and over again. Every bullet has a lawyer attached to it. Yes and no. Every bullet has a lawyer civilly, for the most part, depending on the state. But the thing is, if you are truly defending yourself from an attack of serious bodily injury or death, that may not be totally true. What will happen is, if you were trying to protect your life and a bullet pushes through a person, or you shot and hurt somebody on the other side of the thing, you are more than likely are not going to get charged for that. Now, if the person dies, the person who attacked you is probably going to go against felony murder charges, and you're not. If you are sincere in trying to defend your life, you are not going to need to have a lawyer attached to every bullet. It's a different word when it comes to civilly, and if you have money, you may have some problem with that. Now, alcohol. There are some states that have alcohol limits, like Minnesota. In Minnesota, you can concealed carry up to 0.04. And therefore, people say, because I can have a gun of 0.4, that makes me clear of any other standards, like the reasonable standard. Now, I'm aware of Florida. They have 3 different levels of alcohol, and I'm not going to get into the weeds with that. Different states may have different requirements as far as alcohol. But do not make the mistake of, because you blew 0.3 or you've had 1 beer or 2 beers, that because it's legal to carry one doesn't mean that you have the reasonableness behind it to back it up. Again, you're going to need to be both subjectively and objectively reasonable in a lot of states that your actions were the perceptions were carried right by an individual, and you may be hampered by that. That may the grandmas and broccoli stock on the jury may think, oh, this guy was drinking for a 2 or 3 hour period. He may have not been a totally reasonable person. So if your state, from my point of view, if you are going to drink, lock your gun. If you are going to carry, lock your alcohol. Right? Do not drink alcohol. To me, that is the safest way to go. And let's be, I'll even put it this way. Well, let's just say in Minnesota you are a .04 or higher. Let's say you're a .06 and you did a good shoot. Well, you're probably not going to get charged for a self-defense, a violation of some sort, an imperfect self-defense charge, but you'll probably be charged with operating a handgun, operating a loaded handgun, loaded. All right, that is something that you really need to deal with. There was an instructor that instructors don't know how to really define things when it becomes a law. We talk a lot about disparity of force, position of advantage, height, weight, sex, ability, that kind of a scenario. And there was an instructor basically said that, yeah, there is going to be an inherent acceptability that most women are going to have lower upper body strength than most men. But then he also goes on to say that if a 6'3" person is going after a 5'3" with a 150-pound difference, be prepared to take a couple of punches. That's not necessarily true. A little girl is not going to maybe survive a couple of punches. Again, you do not, if there is a clear disparity of force, you're still going to have to express yourself. You are still going to have a good narrative that says there is a disparity of force because of this factor, and that's what put me into a reasonable fear of great bodily harm or death, and then I shot him. Your narrative is going to have to corroborate that. Hopefully there's going to be some physical evidence, like the guy is 6'5" and 150-pound difference between you. Those are the factors that you're going to need to have, but the attack doesn't have to be an actual attack. The word is imminent attack. You do not have to wait. And I'll just say this: the same instructor said that you have to wait till you're hit with a golf club before you can use deadly force. I want to back up a little bit. Every time that an instructor gets into the legal defense of self-defense, there are a ton of questions. It is the most, when I experience it, it's the most hand-raising kind of a scenario. What if that, this, this. It is the most clearly understood part of our lives when it comes to concealed carry. And the instructors are failing people. The instructors are giving them non-advice. The instructors are not walking through innocence, imminence, proportionality, avoidance, and reasonableness so they can have the knowledge to get to the answers themselves. Because when you're teaching, you are not giving legal advice. You're giving educational information. So you don't have to take a blow. You don't have to wait till a golf club hits you. The disparity of force between men and women, they're getting it wrong. Castle doctrine. The last 8 instructors that I've had since April did butcher the castle doctrine. It was everywhere. About half of them said that Minnesota does not have a castle doctrine. Technically, they're right. There is nowhere in Minnesota black letter law that says that Minnesota has a castle doctrine. But I guarantee you, if you are listening in any state Any 50 states, just because there isn't a black letter law that there is no castle doctrine, just because there isn't a court case that says castle doctrine in it, you do not have a duty to retreat when you're in your home and it is clearly broken in. Your reasonable standard has been met just by the breaking of the door. Now, I'm not going to get into the weeds with this real close, because when it comes to castle doctrine, every state is going to be different, and it has its little nuances. That's why when I talk about self-defense law, I go innocence, imminence, proportionality, avoidance, and reasonableness. And if you know the parameters of all 5 of those, and you take them into consideration, you are more than likely going to be not going to jail. You are more than likely are going to be not what the prosecutor is going to want to get to you. All the castle doctrine does, all stand your ground does, is remove one or more of those requirements conditionally. If it's not reasonable, those conditions could be put back on you, and you have no control of that. So don't rely on the presumption of reasonableness, the presumption of proportional force, avoidance, and all that other good stuff, because there may be some hoops that in your state that you're going to have to jump through. And are you going to be having a flow chart? Oh, I met that requirement. It's not that requirement. Because let's face it, some states, if you have to defend yourself against a roommate or a husband or a wife, you have a duty to retreat. So when it comes to castle doctrine, it's a rabbit hole issue. Stay on innocence, eminence, proportionality, avoidance, and reasonableness. This is one that I didn't expect the instructors to know, but 3 out of the 8 instructors had questions from rape from women. There's something called the battered woman syndrome. And basically what it does is it removes the immediate standard on battered woman syndrome. Let's just say that a woman was held captive and has been raped 6 or 7 times over an 8-hour period. And her attacker was sleeping. She managed to get loose, found a knife, and put it through his heart. That is what battered women syndrome is it alleviates the immediate standard. All 3 of these instructors basically told these women, you can only use defensive, deadly force if you are about or currently being raped. Totally unforgivable. That is the information that I just dread. You're basically declawing these women. You're basically ripping every tooth out of these women's head to fight. That you have to wait till you are about to be raped? No. Now, I'm not saying that if you can get away, you can just go ahead and shoot somebody. If you can get away, you should be getting away. I am not promoting women just to wait till the opportune time to shoot somebody. If you can get away, get away. But if you cannot get away and you shoot somebody who's still asleep, there is a legal doctrine of the battered woman syndrome that will alleviate this. This is another one. This is another one that baffles my mind. I can't remember how many, but it was, I want to say maybe 5 were talking about dog attacks. And the dog attack question never actually comes up in class. It's always during breaks where people are coming up to the instructor and asking them about self-defense. Let me make this totally clear with dogs. This can be, when you are defending yourself from a dog, it's not a self-defense claim. There may be some states that has a law that allows you to shoot the dog to save yourself or another. Other states, you're going to have to use the doctrine of necessity defense. Now, what the doctrine of necessity does is it weighs the lesser of two evils. That you had to shoot and kill a dog within the city limits. Sometimes shooting a gun within the city limits is illegal. It is waived because of the doctrine of necessity, the lesser of two evils. Sorry, guys. Shooting another dog to save your other little dog? Most states you can't do that. That is not a self-defense claim. And in a lot of states, you may not be able to use the doctrine of necessity. This isn't a self-defense law. I am out of my lane when it comes to this type of information. If you want to know greater advice when it comes to defending your dog from another dog, you need to consult your local competent attorney on that specific scenario. There's also a lot of people want to know, well, what happens if someone breaks in and just takes a TV? Well, again, this is castle doctrine stuff. If someone breaks in every single state, you have an assumption of reasonableness that you are going to be in fear for your life or great bodily harm. But if the person is 12 years old and goes after your Nintendo box and runs out with it, should you shoot them? I've literally had talks with some people, oh yeah, if someone's going to take something out of my house, they deserve to die. Well, what are we really talking about? Are you in fear for your life or great bodily harm at this point? Or are you angry that this little 12-year-old punk had the audacity to break in my door and go after an Xbox game and leave with it? Are you in fear for your life or great bodily harm? Or are you pissed off? Do you have that red, steaming ears feeling? Or do you have that cold hand feeling of fear? Which one is going to be more likely? That is a rabbit hole issue with the castle doctrine. Again, if you deal with innocence, imminence, proportionality, avoidance, and reasonableness, you don't have to deal with those rabbit hole issues. You don't have to figure out if some lawyer in a courtroom somewhere is going to take that reasonableness, that presumption of whatever away from you. You're not going to have to do it if you have articulated exactly all what the law requires. There are several others, but this is getting a little bit too long. I can go on and on with the errors that I've listened to in the last 5 months or so, 5 or 6 months. It's why do you think that people aren't passing these tests? I know we had some of the people who took the test and got back to me. They were 7 and 8s. That's a lot better than 5. I hope that whoever's listening or who's been with me for a while got better than a 5. Really good. You know, that test basically said that 13% of over 17,000 people got a passing grade. If you consider a 7 a passing grade. 13 people had a 7, 8, 9, or 10. Isn't that horrible? My name is Jeff. This is 2A Self-Defense Law. I hope this helped.